Moving on from Article 32 of the Constitution of India, one of the interesting provisions in the Constitution is in relation to, say, armed forces and fundamental rights. You will notice that Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of the armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. The objective of this provision is to ensure that the armed forces or the paramilitary, the police, and the intelligence, they uh, discharge their duties and maintain discipline among themselves. And hence, fundamental rights such as freedom of association or any other right of the armed forces, like freedom of even speech or expression, may be curtailed. And these laws, if made by the parliament, cannot be challenged in any court of law on the ground of intervention of fundamental rights. So, the exception to fundamental rights is that it is applicable to all citizens of India except to the members of the armed forces, as provided by a statute of the parliament which may restrict these fundamental rights. Now, accordingly, friends, the parliament has enacted the Army Act in 1950, the Navy Act and the Air Force Act also in 1950, the Police Forces Restriction of Rights Act of 1966, the Border Security Force Act, and so on. These legislations, they usually impose a restriction on freedom of speech. For example, freedom to form association, right to be a member of a trade union or a political association, and right to communicate with the press, and right to attend public meetings or demonstration. Now, I think you will notice that when we say the armed forces, uh, you please note it covers all employees in the armed forces, including barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors, and those who are in non-combat positions as well. The Parliament law enacted under Article 33, which is the saving kind of an article, can also exclude court martial from the writ jurisdiction of the Supreme Court and the High Court so far. So, 32 may not be applicable as a fundamental right to the armed forces. I think, see, you will notice that this is generally called as the martial law. And martial law is very, very important, and to some extent you will notice that it affects fundamental rights of the armed forces. Uh, it usually suspends the writ jurisdiction of the court, and usually you will notice that such kinds of law can be imposed in certain parts of the country, not entirely. And hence you will notice that while a national emergency is one of the rare phenomena which will affect all citizens, martial law only affects those in the armed forces. So, while national emergency also suspends certain fundamental rights, martial law suspends it permanently till the time you serve in the armed forces, or even later than that, depends upon those legislations as well. So, national emergency is for general citizens, and martial law is for the members of the armed forces. Okay, so I think it's very clear that fundamental rights sometimes are not required as an absolute rule, and certain people and citizens can be exempted from the same. And martial law, military law, as we would want to call it, is a situation where those in the military, those in the police, those serving the government are to exercise caution, and their rights are subject to those special laws and cannot be a declaration of rights under general. Okay, that should be kind of a small discussion on martial law. We go further to another article. This seems to be very important because there were two provisions in the Constitution: Article 39, 1F, and Article 19, 1F, and Article 31, which deals with right to property. I repeat, Article 19, 1F and Article 31. Now, originally, right to property, friends, was one of those seven fundamental rights guaranteed under Article 19. Now, Article 19, as I said, has only six. And this said that every citizen shall have the right to acquire, hold, and dispose of property. On the other hand, Article 31 guaranteed to every person, whether citizen or not citizen, the right against deprivation of his property. So, if the property is acquired or it is deprived, then you have a guaranteed right against such deprivation. Rather, Article 31 said that no person shall be deprived of his property except by authority of law. It empowered the state to acquire or requisition of or require the requisition of the property based on two conditions. One is public purpose, but based on the payment of compensation. However, you would notice that the Parliament has tried to amend right to property several times because this was a bone of contention during our initial days of independence, because most of the lands were with private citizens and the government wanted land to develop its governance model. Also, the government wanted to establish a lot of businesses so that it can promote welfare and other things between the states. So, the number of constitutional amendments that have touched right to property include the first constitutional amendment itself, the fourth, the seventh, the 25th, the 39th, the 40th, and 42nd amendment. And there have been a lot of modifications of what this right to property should be, and various of these amendments were challenged in the Supreme Court. The Supreme Court had its own view on how this right to property can be contravened and how it should not be contravened. There were multiple litigations because acquisition of property became a very critical factor for both the central government as well as the state government. And the real bone of contention was, if your right to property is a fundamental right, your compensation should also be equivalent to the treatment of that right. So, what should the state pay as compensation became a real problematic situation. And hence, by the 44th Amendment in 1978, totally this right to property was abolished, and it was taken off from Article 19(1)(f) and Article 31. And instead of that, a new article was inserted in the Constitution in Article 300A under the heading right to property. So it was not continued as a fundamental right, but it was brought in as a constitutional right. Right. So this is now a constitutional legal right to property, but it is not part of the basic structure of the constitution. It's not part of the fundamental right, and hence the implication is that your property today can be regulated, it can be curtailed, it can be abridged, it can be modified, and this can be done through the ordinary law of the parliament. So it's no longer core and fundamental right, as the case may be. While private property is protected under executive and legislative action, please note there is no absolute protection, and the state, under a concept called eminent domain, can take away your property as well. Can the aggrieved party today move under Article 32 to the Supreme Court or under Article 226 to the High Court? The answer is under 32, no, because 32 is only for fundamental rights. Right to property is no longer a fundamental right. But can you go to the High Court under 226? The answer is yes, because today right to property continues to be a legal right and a constitutional one. So high courts can intervene, but Supreme Court directly cannot intervene. And finally, please note, because this is no longer a fundamental right, you do not have a guaranteed right for compensation. The compensation will be determined under the statute, and that shall be almost the fine. Of course, land acquisition in India has been a bone of a lot of contention, both for how it is being acquired and what is the kind of compensation being given for land acquisition. It has been a bone of contention, and that's why the Parliament in 2013 enacted a law called the Fair Compensation to Right to Land Acquisition, Rehabilitation and Resettlement Act of 2013, which replaced the old Land Acquisition Act of 1894. It was a British era law. However, please note, the 4 times market value compensation that is promised under the 2013 Fair Compensation Law is not practicable, and hence that law has stood good on paper but has not been implemented in actual reality. Okay, I think that's good enough. We move forward, friends, from the chapter on part 3 of the Constitution dealing with fundamental rights to what we must say, the directive principles of state policy. But before we do that, though fundamental rights have been appreciated as a very good part of the Constitution, they are the heart and soul of the Constitution. Uh, uh, so the Indian Part 3 Constitution has been appreciated by a lot of people, and they are very significant, right? Why they are significant? Because the fundamental rights are the bedrock of democratic systems in our society. So, the, the value and the way in which fundamental rights are experienced and enjoyed by the citizen also talks a lot about how the democratic values in the country are. Of course, there is a formidable, force of protecting individual liberties under the Constitution, and this has only strengthened from time to time. What does fundamental rights do, friends? Fundamental right helps us establish what we call as the rule of law, not rule of men. So, rule of law seems to have been strengthened as well, thanks to the protection and promotion and kind of intervention in case of infringement of fundamental rights. I think fundamental rights brings in a status of equality because minorities also have protection. It checks the absoluteness of government authority or power. It also is the foundation. See, please note, fundamental rights is the foundation of justice in our society. What kind of justice? I think social as well as economic justice. I think fundamental rights does provide for the same. Do fundamental rights ensure the dignity of the individual? Does it talk about respect to individuals? And does the state have a duty to the same? I think yes. And finally, do fundamental rights provide an opportunity for citizens to take part in the democratic process or the administrative process of the country? The answer also is yes. However, on the flip side, there have been some, observations on what fundamental rights ought to have been, and can they be much better than what they are right now. So a lot of people, view that fundamental rights are unfortunately to experience, exercise, or even take recourse to any kind of infringement of your fundamental rights in India. The legal system or the judicial system that we have created for redressal of these grievances against fundamental rights or for the violation of fundamental rights are unfortunately very expensive. They're very tedious. They're very time consuming. So while it's good to have these rights and it's good to experience this right, but the way the fundamental rights are to be exercised or experienced through the judicial process in terms of right to be enforced or right to be enjoyed, I think it's quite an expensive, tedious process in India. I think the procedure has to be simplified. The procedure has to be more tuned to the common man. Even whether you're literate or not, your access to justice must be free and fair. It must be reasonable. It must be speedier. Otherwise, it fails the whole process of having it in the constitution. To these fundamental rights, interestingly, have very dynamic interpretation by the courts of law. While the basic kind of architecture of each of these rights is laid down, how it is to be applied in each cases probably varies from time to time, and hence, a lot of people think that there is no consistency of how these fundamental rights are to be enjoyed. There is no kind of permanency of saying, okay, this is all what the right contains. So, if someone has to understand, say, freedom of speech and expression, you have to go through the several judgments of the Supreme Court from time to time, and each judgment actually may have its own contribution to make about what this is. So that also has added to the flaw of the rights being experienced, or what I would say in terms of justiciability of the rights as well. Also, uh, you know, if you see the kind of restrictions on fundamental rights. Now, if one goes to Article 19.2 and tries to look at the restrictions of fundamental right, one will assume that there are too many restrictions. Maybe it is time that these restrictions are narrowed down and kept to its very basic. For example, some of the restrictions under Article 19.2, just for our instance or example, we must look into it, are very broad. Like, for example, we say you cannot enjoy any of your freedoms unless, to the extent that it violates interest of the state or the security of the state or the sovereignty of the country. If it infringes the friendly relation with foreign states, if suppose something from your speech and expression contributes to public order, violates decency, or morality, or is in contempt of court, or defamation, or incitement of an offense. In all these circumstances, you will notice that your right is curtailed to that extent because these are reasonable restrictions on your freedom. So while no right should be absolute, the restrictions on these rights must be to the very minimum basic. For example, defamation, the law on defamation, the law on sedition for that matter, these are very interesting laws that, though have their own justifications to remain and stay, they can be misused, and people may be tempted to fall litigations, either false or fake, or just to create some kind of process. Uh, and I think people may be hesitant to explore and experience their fundamental rights because of these restrictions that are present. So I think limitations or restrictions under the Indian Constitution may at some time be considered as excessive as compared to other countries' constitution. But I would like to believe that it's an unfair criticism. I think those limitations are very basic and essential. And I think over a period of time, a debate on what should be there and what should not be there can always be taken forward. But they have actually withstood the test of times, and they have actually brought in a more responsible society that is enjoying its fundamental rights. Another criticism of fundamental rights chapter has been that most of your social and economic rights, say right to work, for example, or right to employment, or some kind of right to social security, or other rights, generally that one seeks to enforce in society, are brought through the directive principles of state policy and not directly. So when we go to the directive principles of state policy, you will notice that most of these rights, which are developmental rights, are actually stated in the directive principles and not in the fundamental rights. So does this hamper a citizen's growth and his developmental aspirations, as the case may be? Especially in a democracy where one looks at right to development also as those kinds of fundamental right. So I think it would be necessary to view and review what kind of new dimension of right to development can be added to the fundamental rights chapter. So one other observation of fundamental rights chapter has been that on certain rights there is literally no clarity, especially suppose you talk about minority institutions and their right to manage educational institutions. The term minority itself has been a subject matter of a lot of judicial decisions. The term minority is subject to a lot of political misuse for vote bank politics. And this has been stretched beyond, I think, the original idea of the framers of the Constitution. So, in the name of minority protection or minority rights, I think we have been able to, uh, uh, do a great disservice to the nation. And I think are some of the contentious points that need to be taken into consideration. I think there are last 2 points that I would just say at this point of time in terms of the observations about what fundamental rights should have been and can be, and why should we, discuss, the limitation of fundamental rights itself is. The two other things are one, this thing about fundamental rights, certain fundamental rights being suspended during national emergency. We have already experienced that in 1975 and 1976. This has been a challenge, though the courts have said that now certain rights cannot be suspended, but yet most of the fundamental rights can be. So I think that is a kind of a danger zone that we are. Why should they be suspended? Is there a adequate justification of the same? Is this kind of a backup provision? Let's see when it is used. We'll see to what extent citizens' interests are going to be adversely impacted. And finally, preventive detention. So, preventive detention laws, have special mention under Article 22, and I believe that preventive detention laws like TADA, so many other legislations, POTA. So these are preventive detention laws, right? So I can give you a list of those preventive detention laws, in a small while, if let's see, I have a list of that because I think it's quite interesting to know the list that has some of the detention laws. Let me start with them. There was an act of 1950 called the Preventive Detention Act. Now, luckily, it is no longer in force. Then we had what is known as Maintenance of Internal Security Act, that again has is no longer in force. We have Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. We have the National Security Act, which I think we brought in 1980. Prevention of Black Marketing and Maintenance of Essential Supplies and Essential Commodities Act. The Terrorist and Disruptive Activities Act, TADA, now it is repealed. Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act of 1988. Prevention of Terrorism Act, repealed in 2004, that is POTA. And finally, you have the Unlawful Activities Prevention Act, UPA, Unlawful Activities Prevention Act, which was amended very recently in 2019. So, the Unlawful Activities Prevention Act and the National Security Act today are critical legislation that deal with preventive detention. So, preventive detention law is an exception to Article 22, and that may at some point of time have to change as well. So, with this, we'll conclude fundamental rights and we move on to directive principle of state policy. We have evaluated this chapter in terms of its strength and some of the limitations it may have. There is always a scope of improvement that we must always know where it can improve and how it should be done.